Hi, everyone. This is Becky Jacobs, and I want to introduce you to our panel, which is Decoding Ethical Design and Practice in Resolving Smart Contract and Blockchain-Related Disputes. And we have on with us today Amy Schmitz from the University of Missouri School of Law, Angie Raymond from Indiana University, and you have a joint appointment on the Law School and Business School. I'm from the University of Tennessee College of Law. Colin Rule is with Tyler Technologies. Erin Archard is at the University of Detroit Mercy Law School. And Marcia Narine Weldon is at the University of Miami School of Law. And Erin, you want to tell us about sponsorship?
Sure. So this is actually a jointly sponsored, co-sponsored panel with the ABA Dispute Resolution Ethics Committee and the Technology Committee. And I'll have Amy speak a little bit more about the Technology Committee. But we've been inundated, really all of us, I'm sure, these last few weeks with conversations about ODR. And that's not really the focus of this panel today. We're talking about smart contracts and how disputes that arise under those are resolved. And so the reason that the Ethics Committee thought this would be a really nice panel to sponsor is because so many of us, and I include myself in that group, know so little about how smart contracts actually work, how they function, that in some ways, whether we are doing it consciously or not, we might be committing some ethical violations, and we'll talk more about that later, simply because we don't know what we're dealing with. And so this is really a great opportunity to delve into a specific area of contract design, and I'm also a contracts professor, so I'm particularly interested in this, and then see how that connects to neutrals, what role they play going in and helping resolve these disputes. So I'll let Amy say a little bit about the Technology Committee's role and their outlook on this.
Yeah, thanks. I think this is really fun. I'm excited that we were able to partner and work together on this. I'm one of the co-chairs of the Technology Committee, and what I think is great about our co-sponsorship of this program is a lot of times people think we only look at ODR as ODR being the only issue of importance for the Technology Committee. However, we're also doing work with smart contracts and considering their implications for dispute prevention, and also how we might actually resolve disputes when they do arise and they work with and they are involving smart contracts. And I also am a contracts professor, and so I share this interest in the topic. And I thank you all for taking your time with us today.
So, Becky, did you have anything you wanted to add before we get started on the background?
Nope, I think let's go. Let's get started.
Sounds great. Well, this is Amy. I'll go ahead and start us off, and I'm going to go quickly because, as I've said, I want to get to the good stuff in talking about the case studies and ethics, which we'll get to shortly. However, I just wanted to set a little bit of background. All of us, and many of us at least, have heard of Bitcoin and the various cryptocurrencies. And in fact, in 2018, there were 1,600 cryptocurrencies. I actually checked just now, and as of April 22nd, 2020, there are 5,392 cryptocurrencies being traded with a total market capitalization of $201 billion. So this is a huge industry that is growing by leaps and bounds every moment. At the same time, you have growth of distributed ledgers, such as, of course, Ethereum, which many of us have heard of, but lots of other private and public distributed ledgers that are being used for various things throughout our economy. Now we're also seeing a mainstreaming of smart contracts. It's not simply something for the cryptography people or somebody who only looks at crypto economics, but other just regular individuals are now able to enter into smart contracts using implementations such as Rocket Lawyer and even law firms. There's also corporate funding. Now in 2018, that was 2.1 billion. Now we are talking hundreds of billions. There's been a dramatic increase in hiring for blockchain related jobs. In fact, one of my relatives who couldn't get a job elsewhere found himself taking a special online course and got an amazing job in the industry. just showing how it's really growing, especially for the younger generation as they graduate from college and look into new ideas. Next. What is blockchain? So as we look into what even is blockchain, basically it's a new system for building trust. You can think of it as kind of trust in a trustless world, right? And so if you're just trusting the math and you're focusing on the math in a distributed ledger, it's a different way of trust where you don't have to rely on government, you don't have to rely on third parties or lawyers. Also, basically, it's a distributed ledger. You have one version of a database record on many computers throughout the world. It's trusted, usually if it's a public blockchain, then it's immutable, meaning it can't be changed, then it's public. There's data integrity, and of course, identity authentication that all occurs in this open distributed ledger. That's when we're talking about a public blockchain, such as Bitcoin. Next. Different core concepts of the public chain. Again, distributed ledger, there's no central authority to hold the ledger or be attacked. All computers, which are what we call nodes when you're talking blockchain lingo, have a complete ledger. But it's transparent but anonymous. The ledgers can be public while concealing identity through cryptographic keys. Private or permission ledgers are also growing in use. The idea of an append-only ledger means that each entry, or what we call a block, is linked to the previous entry via some algorithm, is what we call a hash. Some nodes, which are miners, are paid for performing these calculations, for example, proof of work calculations. As sort of a side note, I did a very fun simulation with my students where they had to act as nodes in demonstrating how this actually works with a public chain. And it was really pretty neat to watch how the students had to see the math is what matters, right? So you trust the math if you're trusting blockchain. The idea of a mutable ledger and why we think it's safer than, for example, storing things in the regular way in a central cloud. Attacks to ledger are impractical, really. I mean, it can happen, but you have to have a majority of the nodes. You would have to have a 51% attack if you're talking about a regular public chain. Next. Some examples, again, Bitcoin employs blockchain model. Smart contracts have been growing in use. I'd say smart contracts are actually starting to become the biggest use for blockchain technology, along with security. Security is really important when it comes to blockchain. In fact, the course I'm going to be teaching next year, having to do with cybersecurity, really focuses on and brings in a lot of use of blockchain, very important for cybersecurity and security of data. Next, disruption. Tons of disruption happening because of smart contracts. You see a lot of its use in shipping, for example, the Belt and Road Initiative in Hong Kong and elsewhere. As I said earlier, security, especially in the finance industry, also in the record-keeping industry. Estonia and India are two examples where they're actually putting public records on the blockchain in order to create greater security. And I think we're turning, healthcare is another area, and of course law with smart contracts and blockchain courts. We even see this idea about Libra and how that might come into play using Facebook and its own cryptocurrency and creating a marketplace that would rely basically on smart contracts and cryptocurrency. So huge disruption in the industry. So I'm gonna turn over the baton and we will move on.
Thank you, Amy. This is Angie, and I'm going to briefly overview smart contracts. So actually, most of you will have an idea in your head of how smart contracts work. It's basically coding a set of functions into one of two ways. You can either code so that you actually create the contract, offer and acceptance happen through technology deployments, or you can execute certain terms of the contracts. And I'm going to give you some examples in a second. So what this is going to do is allow the computer code to self-execute what is occurring in the process. And so this is actually done through a series of if-thens. And so there's two ways to think about this. Imagine you're FedEx, and most of us get that email notification that says, hey, label created. you get there, you bought something and you're wondering when it's going to arrive. You log into the FedEx account and you see label created. Well, that's a process that we could automate. If the label was created, for example, or maybe the box was loaded onto the truck, when they scan the code, that could be a command that is executed that prompts payment to occur. So loaded on the truck, that moment that the FedEx person is loading stuff on and scanning codes could then charge my credit card. The same could be true, of course, and this process is a lot more complex than you might realize when you think about, if you've ever had a 3 or 4-year-old, your decision at some point in your life to say, it's bedtime, as opposed to listing the 38 things that go into getting into bed. So imagine the 3 or 4-year-old who you say it's bedtime and you walk up to the bedroom and you realize no teeth brushed, absolutely no PJs on, fill in the blank. When we use if-then coding, what you're talking about is each and every one of those steps is broken down, and some of those steps will result in payment or the beginning of the shipment process, fill in the blank. It's actually pretty simple in its most basic form. So I don't want to spend a whole lot of time on that because we really want to get to some of the juicy stuff. So let's talk about some of the benefits of smart contracts. First of all, actually smart contracts, or the idea behind it, has been around for a while. So this automation of business processes is not new. What is, of course, new is the blockchain type environment where we create hashes that actually are then storing particular actions in a blockchain environment. But the speed and efficiency of a smart contract is without argument at this point in time, for the most part, assuming that things are set up correctly. Of course, the autonomy of the system as well. So you no longer have to wait for Betty or Bill to actually enter things into the process, to actually enter your credit card details. All of this can be autonomous. We don't have to rely on external third parties. Imagine, if you're like me and teach commercial law, the bill of lading process in this particular process, and we'll talk about that later. Of course, there's trust and transparency. Again, as Amy spoke of, not all of these are transparent necessarily, but they are at least transparent amongst the group of you who agree for them to be transparent amongst you, which adds to the process altogether, as well as encryption and security, which I don't think we'll talk about much today, but that's a whole separate webinar if you should ever want to hear it. And they're immutable, meaning that once something's entered into this system, it can't be changed. It's good. That's a good and bad process. And we're going to go through these smart contract examples in a second, but I want to leave this slide up here for just enough so you can see how many different areas smart contracts are being used, and maybe just as importantly, what areas they're not really being used. So unfortunately, there is a lot of hype about this stuff, and I'm not telling you that smart contracts or blockchain should be used everywhere. So interesting conversation later, but these are the areas that really have taken off in this particular area. And now I'm going to hand it over.
Thanks for having me on. I'm really glad to be able to share this information with the ABA. My interest in smart contracts comes from my background. Before I became an academic, I was a compliance officer and privacy officer for a logistics company. So when I first heard about blockchain, I was never interested in the crypto and those kinds of things. I was always interested in the practical use cases. And right now, my research interests deal with business and human rights, compliance, corporate governance, and I'm going to show you some examples of how this is being used, just to give you a bit of a flavor. So the most obvious way is shipping and logistics. There's this program called TradeLens, and IBM TradeLens is what's called a permissioned blockchain, and you'll be learning a little bit about that in a couple of minutes. But this is right now handling over half of the global shipping trade by volume. And what it does is it has an interconnected circuit of supply chain partners. So your cargo owners, your ports, your ocean and inland carriers, your freight forwarders, your providers, your ports and terminals. And it provides a secure audit trail all the way through. Having been in the logistics industry in the past, and for those of you who may be lawyers who deal with this, you know that there can be hundreds of sheets of paper all over the world in different languages. It's easy to have errors. It's easy to have fraud. So this is a really great way to streamline that process. Next slide. Another area, for those of you who've ever heard of conflict diamonds or ever watched the movie Blood Diamond, the area of provenance is another area where this is being used. Not just so that you can be sure that the diamond you bought in Tiffany's was not mined by child slaves and those kinds of things, so you can feel good, but there are a number of regulatory regimes, both mandatory and discretionary, which require provenance and supply chain tracing from the mine to the store. So De Beers is a company that has now set up a program called Tracer Diamond from the mine to the store, including the family-owned jewelry stores, and they've opened it up throughout the entire diamond supply chain. So number one, this shows the provenance, shows the authenticity, and so it's good from a sustainability, ESG perspective, but it's also being used in a number of areas where there are mandatory disclosure regimes. Next slide. Food traceability. Some of you may remember a few years ago when you couldn't eat spinach, or you couldn't go to McDonald's, or you couldn't eat beef because of E. coli. So you have IBM has done a food trust, and there's food traceability. You may have heard Walmart has now required all of its vegetable growers to have their products on the blockchain, which means from the time something is picked to the time that it ends up in the store, this can be traced. Why is this important? When there's a recall, it costs an average of $10 million. You also have a number of small family farmers that go out of business, not to mention the significant health issues. What IBM has done is participants can do different levels of it, but even down to the ingredient level, they are making a way so that they can do traceability. Number one, this is good for public health, but from a business perspective, it's good because there are a number of regimes around the world which require you to be able to talk about food traceability. Next slide. Financial services. This is called WeTrade, and right now it's taking place in Europe, and this is finance trade. Small and medium-sized businesses have huge problems when they can't get paid on time. So what WeTrade aims to do is to make sure there's a guaranteed payment when the contractual agreements have been met. Right now, 55% of its transactions are automated. It's a joint process with several banks. It's also being used for KYC, or Know Your Customer compliance. And this current situation right now, where a third of small to medium-sized businesses have to wait 2 months to get paid, that's what this is trying to do. And the use of smart contracts is making this a much smoother, seamless process. Next slide. Encryption. I learned about this a few days ago, actually. I've done a test on Ancestry DNA and 23andMe. And of course, those companies own that data and they sell it. And for those of you who don't know, your medical data is much more valuable than your social security card. And what encryption does is it allows you to have your data stored on this blockchain along with other information. It's going to be anonymized, and you can then sell it and transfer it. So you can make money off of your own DNA. It's also being used to transfer medical data back and forth between medical professionals and doctors. But again, it's being done in a secure way. It can't be altered, and it's going to be there forever, but allows some ownership. Block Pharma is a French company, and what they're dealing with is the issue of counterfeit drugs. There are over 800,000 people die every year with counterfeit drugs, and there's an estimate of 10 to 15% of drugs out there are counterfeit. So Block Pharma is using the blockchain to trace the origins of medications from their production to the point of sale. Particularly important for regulated companies that need to be able to do this. In the United States, I think it's by 2021, you have to be able to do the drug traceability, and it's all around the world. So this is how smart contracts are being used for that perspective, where customers can actually check to see if their purchased medicines are falsified. Next slide. Lemonade, the #1 most popular renter's insurance, but they don't have it in Florida. They can actually use smart contracts to be able to pay you within 3 seconds by using blockchain and AI and a number of other kinds of algorithms. It's the world's first peer-to-peer insurance. And if a claim is made and authenticated, the smart contracts will go into play. You never have to talk to a human being. You basically talk to bots. You do a recording. They have their AI algorithms, and you can get paid out. Next slide. B3I is a consortium of insurance and reinsurance companies around the world that are trying to figure out how they can eliminate duplication of data across applications and parties to reduce the friction, and so they can have a single source of truth, which is what smart contracts and blockchain provide. And it's owned by 20 insurance market participants around the world. Next slide. you'll recognize all of these companies, oil and gas consortiums, and try to figure out how they can use blockchain and smart contracts for governance structures so they can validate assets, deal with hydrocarbon accounting, digital letters of credit. And then the last slide, the next slide, to add something to be a little bit topical, depending on when you're watching this. The reason we're not in New Orleans right now is because of COVID-19. There are a number of people who are saying, perhaps we should be able to use all the data that people are putting in from the testing and the antibody tests so that people around the country and around the world can keep track of it. Obviously, there's some concerns about privacy, but this is something that's being looked at. If you could have a single source of truth, how you could do contract tracing, et cetera. The US Senate had a memo they haven't acted on April 30th, where they're looking at remote voting via blockchain, because how will they get back into session? And then also things about tracking and tracing meat, with all of the issues with the meat plants in the United States that have had COVID outbursts, and we're not really sure what's going on with the meat. So that's another way where people are going to use smart contracts and blockchain, or at least ways that they're thinking of. Next slide.
Fantastic. I think that's me. So maybe I'll step in here. Thank you so much, Marcia. I mean, it's funny, I'm based out here in Silicon Valley. We have so much excitement around blockchain and smart contracts. I mean, there's startups everywhere that are trying to apply this technology. And I think your slides really point to a lot of the exciting opportunities in the space. It kind of reminds me actually of the early days of e-commerce. And there was some thought back when we were creating these marketplaces. There was a notion of private marketplaces and public marketplaces. And suddenly all these corporations started to utilize that technology to improve their internal operations. So there's just innovation breaking out all over the place. Now, I think it's kind of funny that I'm the one on this call that was assigned to talk about this slide, because I think I'm the non-lawyer mediator on the call. It's a little unnerving to talk about contracts in front of all these contract professors. So Amy, you're gonna have to help me out here. But you know, my primitive understanding of contracts, you get into this whole idea of offer acceptance and consideration. At least that's what Amy has educated me about. And the question is, are smart contracts really contracts? I mean, if I have an agreement with my virtual, digital currency provider that if the price goes above a certain level, I automatically purchase X number of coins. Is that really a contract? I mean, the way that we think about contracts, when we start to think about decentralized justice and this whole sort of new justice system backed by math instead of the coercive power of the state, it's a bit of a reach to say, okay, well, is this system really a justice system in the way that we think about the justice system? And the concepts we have within the justice system, do they map one-to-one? So when you think about a lot of the smart contracts that are out there, if you take a look at them, they're actually pretty simple, very if-then kind of statement contracts, agreements. So the notion that they have the same sort of level of sophistication and enforceability and theory behind them as actual paper-based contracts with wet ink signatures, I think that's a bit of a debatable proposition. But obviously, there's no identifiable jurisdiction around these smart contracts. Once you back them with math, they can live anywhere. They can be in any blockchain, any place. And it's anonymous. You don't really know who the parties are. So how would you enforce a contract if you can't even really figure out who signed this smart contract? So, I think, again, Amy, you need to speak up in terms of the complexities around civil law and common law, but just the requirements around what contracts have in those legal systems, it's not very clear that smart contracts have those same things. So are we talking about apples and oranges, or is there enough of an overlap that we really can use all of the long experience in terms of law around contracts and then use that to educate us about how smart contracts are going to be administered and implemented? So Amy, I don't know if you want to weigh in on that. Okay, we'll keep going.
No, you did great.
Yeah. Okay, good. Whew. All right, that's the load off of my mind. I'm a little bit more on safe ground here when we talk about private.
I'll send your grade later.
Okay, that's all right. Amy and I, we like to tease each other. So if she comes after me, just know it's from a place of love. So in terms of private and public chains, again, this does make me think of the early days of what we call these massive online marketplaces. And people think about eBay and they think about some of these big public marketplaces for buying and selling goods, but a lot of businesses actually built private marketplaces, which were captive marketplaces where only their providers could participate, and they would set all the rules around them. And I think that's what we're sort of seeing with the use of blockchain. I mean, obviously the people that set up Bitcoin, they had, as you can see in the last bullet, they were libertarians, and they were trying to set up a system that was publicly accessible and backed by math. The trust came from the code. But now what's happening is people are starting to take a look at this technology and say, wow, this could be useful for lots of private applications. And some of these big consulting firms, they've built practices building private blockchains, private chains for businesses to handle internal operations. So, I think we need to evaluate not only how this technology will apply in the public context where we don't know who the participants are, we also need to think about how it's going to deploy in permissioned environments where we do know who all of the participants are, and the rules are sort of set amongst those participants. So then some of the issues that people have with the use of smart contracts in the public can be addressed within these sort of private ecosystems. So I think it's true, the future may be the use of these private chains that the public never knows about, but it undergirds the entire industry. Like food traceability is a perfect example. I go buy bananas at Walmart. I don't understand all the technology to trace that from the, where it was going all the way to, the place where I buy it. But that may end up being 10 times as big as the public chains that I do know about as an end user. All right, so next slide. All right, so the other thing about business people versus lawyers is business people ignore all of the potential problems that may arise downstream because they're all excited about building stuff and all. And then when the lawyers come in and say, well, did you think about this? Well, did you think about that? The business people are like, you guys, you're just wet blankets, of course, until a problem emerges. And then they say to the lawyers, why didn't you tell me about this? So we often think in our world about all the issues things that can go wrong. And I remember actually being at an ABA dispute resolution section conference, gosh, this must have been 2000, 2001. And I saw a presentation on electronic document interchange standards, which were sort of an early way for contracts to, agreements to be enforced. And the presenter stood up and said, once we have EDI widely deployed, we're not going to have any more disputes because technology is going to solve all of the disputes. There's never going to be any misunderstandings. And Ethan Katch, who's the real father of online dispute resolution, was in the audience, and he stood up and said, respectfully, sir, the power of technology to resolve disputes is dwarfed by the power of technology to generate new disputes. And I think that is 100% true in this area too, especially when you've got all of these complicated unanswered questions. There's going to be tons of issues around smart contract enforcement. And you can see a sample of them here. Breach, failed performance, encoding errors, lack of capacity, incomplete contracts, enforcement. There's going to be many issues that emerge, even once the system up and operating at scale. And hopefully over time, we'll be able to resolve a lot of these issues, but we need to think about how are we going to deal with these issues when they arise. For instance, imagine that I have a smart contract with Amy, and it says, okay, Amy built a website for me, and if I get 1 million hits, I'm going to pay her 10 Bitcoin as a bonus because I got to 1 million hits. Well, okay, great. We write a smart contract and we both sign it with our cryptographic keys and we drop it in a blockchain so it can't change. And then it's waiting and it's monitoring the performance, right? It's monitoring how many visitors are coming to hit the website. And then one day it crosses 1 million and boom, the smart contract is triggered and then I have to send the Bitcoin to Amy. Well, what if I feel that the smart contract, the data that's been fed to that smart contract around user visits to the website has been monkeyed with in some way? Maybe I don't trust that data. So yes, the smart contract executes and I'm responsible for the obligation in that smart contract, but I need to be able to say, hey, wait a minute, I think that this has been monkeyed with, I have an issue and I want to file a complaint. So that may be breach or failed performance, or that may be a coding error. How are we going to build systems that are going to respond to these smart contracts? A lot of the coders think, oh, this is great. We'll all write these computer programs. We'll drop them in these unalterable global ledgers, and they're just going to execute. And it's fantastic. We then have a justice system. But we know that that's not the way these things work. We have to have mechanisms to be able to deal with these disputes when they arise. And that's really where ODR is fitting into it. So next slide. I think this may be the last one for me, and then I'm going to hand it back to you, Amy, or somebody else. But the point is, this was the big problem on the internet. Again, I was in the e-commerce wars, and this feels just like the e-commerce wars to me. At the beginning, it's like, well, who do you trust? Who do we know? You know, who are these people? Like, I'm engaging with transactions all over the place, and we may be exchanging cryptographic keys and using these mechanisms, but there's a lot of bad guys that are out there trying to figure out, well, how can I, you know, manipulate this process and tweak it in order to benefit me? So again, backing all of this with math is great, but if nobody's in charge, if it's just a peer-to-peer process and we're all kind of looking at each other like, okay, who's going to run this? What happens when a compromise occurs? And you think about some of these large cryptocurrencies, they've been compromised at scale. Now there are people who are trying to actually compromise blockchains, which is very complicated to do, but there's some experience that shows that that is potentially possible. Imagine we get to a point with quantum computing and then essentially all of our encryption falls because people can solve unsolvable math problems before. So the question is the government just going to let this run? I mean, this is a massive subtraction from government jurisdiction if everybody starts building this math-based global system. Because, you know, well, it doesn't even matter what the courts say because I've already put it on the blockchain. So it transcends any individual government ability to manage it. So, you know, is it reasonable for us to talk about self-regulation of these systems, or is that just, you know, libertarian claptrap? Who knows? We'll have to see. There's a lot of questions that are yet to be answered. But, you know, the justice system in the past has been human powered. And we've really relied on human judgment to power that system. And if we are thinking about truly building a decentralized system where it's all automated, and we say in ODR, talk about the third party is the human mediator or arbitrator, and the fourth party is technology. And it may get to the point where we trust the fourth party more than we trust the third party because we just think that the humans, you know, it's a little bit better than flipping a coin. But it's going to take time for us to build trust in these mechanisms, you know, especially when there's going to be near-term compromises as we kind of work out the kinks. So, you know, we've gone through this with the internet several times, and we're going to do it again. And that may be what's ahead of us over the next decade or two. So I think that's the end of my slides. Just go back to you, Amy.
Yep, back to me. So thank you very much. And kind of as you think about this and kind of my research, I guess it started a couple of years ago, is I started looking at sort of the different ways that blockchain related disputes were being resolved. And as I am a nerd, I kept a chart. I started researching and gathering information about all these different groups and trying to sort of put them into pockets of what type of dispute resolution was beginning to emerge with respect to smart contract disputes in particular. And I, like Marcia, have been more interested in the smart contract aspect than the cryptocurrency aspect. So I'm really kind of looking more at the smart contract disputes and the smart contract dispute resolution in particular. And what kind of jumped out at me, a couple of things. Of course, whenever I think about dispute resolution, I'm thinking about fitting the forum to the fuss, right? So kind of a functional analysis and problem solving aspect. I like to think about what is the problem we're trying to solve, and then what is the best way to resolve that particular type of problem, given its constituencies, given the particular issues and values that are part of that system. And one thing I found is kind of three main types of dispute resolution have emerged with respect to blockchain related and in particular smart contract related disputes. And the way I kind of parse these out, and the article that I wrote with Colin, Resolving Smart Contract Disputes, actually kind of goes through these for those that are interested. And I think we provided the article along with this panel. So you can find that on the ABA's website. So first of all, with respect to arbitration on the blockchain, certainly we're seeing that with OpenBazaar and many others. There's ECAF, there's a bunch more now that have grown in this area where they are setting up kind of specialized arbitration panels for blockchain related disputes. Incidentally, more recently, I've seen JAMS, for example, and the AAA both getting in on the game and also providing expertise with respect to blockchain related dispute and having arbitration available. Next, you also are seeing crowdsourced dispute resolution. And perhaps this is what is kind of the most interesting from a blockchain perspective, because what we're seeing is tokenized voting on the blockchain. And we're going to get to some case studies in a bit here, so I'm not going to go into too much depth. I'm just giving the broad kind of background, and then we are going to jump right in a little later in this presentation. But some of the examples include Claros. I'd say Claros is probably the biggest game in town as far as a provider that is using crowdsourced, tokenized dispute resolution. Jur is another, Aragon is another, Delphi, Rhubarb, and many more that are out there. What does that mean? Tokenized dispute resolution. What we're talking about there is where basically a jury of your peers, meaning other token holders, look at the facts and evidence and vote for the party they believe will win. Now, I say that the party they will win and not necessarily the party that is right, because if you choose the side that eventually wins, then you will win tokens. So the incentive is to choose the party you think other jurors will vote for, right? And that can beg the question, does that necessarily mean it's justice, or are we just going with where we think the sentiment or the crowd will move in that direction? Now, ideally, if you sort of think of it from game theory, you would argue that individuals would want to choose the best, most just, most correct decision, because that will most likely be the winning position. But that is a little bit subject to question. So that becomes a controversial issue, and we're going to get into the Doge trial, which was done by Claros a little later in this discussion. Another option is automated bot resolutions. As Colin mentioned, there is a lot of discussion about going from human third party to automated fourth party dispute resolution. And it just may be that it's an area where efficiency is tantamount, and therefore an automated bot resolution may be precisely what the parties want, given the circumstances. The question I ask, and which I think is important for all of us to ask from an ethics perspective also, is are these processes designed with dispute system design principles in mind? In fact, even the way I teach my ODR, my class, Dispute Resolution in the Digital Age, is I think specifically from a design perspective. How can we use technology to improve the way that we resolve disputes in a particular context? Next slide. So when we think about dispute system design principles, just briefly, we think about who are the leaders. And in this area, it's really kind of unclear, again, who's going to take initiative and ensure quality control with respect to dispute resolution in the blockchain. There had been a consortium that was growing about 2 years ago, but is now dissipated and no longer seems to be in charge. Design process. Again, we have to think about who are the stakeholders as well as the process users, and think about design process when we think about proper principles. Also pluralism, considering, again, functional analysis and fitting the form to the fuss and allowing for different means of resolving disputes that work best for the particular parties and the type of disputes involved. Also ongoing commitment, providing resources, incentives, learning and improvement, possibly audits on the system, again, thinking about who's in charge. Next slide. Some major issues that come up with respect to system design and blockchain dispute resolution, especially from an ethics perspective, is we have to think about conflicts of interest. We think about bias and power relations. Certainly, this is an area where repeat players could end up essentially controlling the process. Using blockchain traits to enhance dispute process is also important. Again, integrity of the data, enforcement of resolutions. Using dispute data for improvement is very important when we think about ODR, especially when you're thinking about blockchain dispute resolution. And I guess for me, one of the most important things is user-centric and practical design, making sure that whatever process we've created, it's something where the users understand what they're getting into, understand the risks, and understand the benefits. Next slide. Finally, regulating smart contracts. Again, this will be my last slide before I turn over the baton. But in sum, what I'm trying to get across through this little portion is, number one, there's several different types of dispute resolution that have been growing in use for smart contracts. Nonetheless, we do need to think about how to best design the processes in order to fit the form to the fuss and to create benefits for the users involved and all the stakeholders. There definitely, I would argue, is a clear need for online dispute resolution, ODR, to resolve smart contract disputes, because the courts are not going to be the best place for resolving these disputes. In fact, right now, as we speak, there are many legislatures that have passed different laws that say that quote unquote smart contracts are enforceable, right? Or something along those lines. But the people passing those laws might not even know what a smart contract is. And that same problem is going to occur in the courts. And so we need experts who understand smart contracts, who are actually resolving these types of dispute. Now, another argument that I've heard is, hey, wait a minute, why do we even care about smart contract dispute resolution? Because I thought I heard that smart contracts are supposed to prevent all disputes, and we're preventing the need for middlemen. We're preventing the need for a dispute resolution process because we're going to code for all possible problems. That is just not possible. That's impracticable to even think that's possible. There will be bugs in the system. There will be fraud. There will be unconscionability. There will be unpredictable behavior by the people who are creating these smart contracts, and even code itself. In fact, I was talking to some coders who work with Claros, and they were explaining how computer coders can disagree about interpretation of computer code depending on where they learned their coding. So there are definitely going to be disputes, and we are going to need a way to resolve them. At the same time, there's great importance of preserving anonymity as well as efficiency, because if those are benefits of blockchain, we don't want to get rid of those benefits by using a court process, for example. And again, I want to put a plug in for ethical design and execution of these dispute resolution mechanisms. If an idea like Libra really takes off and Facebook has its own cryptocurrency and marketplace built on smart contracts, you better believe we need to have a way to resolve the disputes that will occur. Finally, the application of iCoder principles and standards. If you go to odr.info, again, odr.info, you will find the principles and standards for ethics that have already been proposed by iCoder. And just again, for those who want to get involved in the technology committee of the dispute resolution section, we are actually working on ethical standards and principles for ODR by virtue of the new ABA ODR task force. And you're welcome to join. I'll pass the baton.
Okay, so I think it's clear from the presentation that everybody has done, some of the issues that arise for people who aren't deeply involved in this, just the questions that come up for people if you're not an expert coder, and people come to you, let's say the smart contract has some kind of code in it that says hash, pause the contract, refer to mediator, or hash, pause the contract, refer to arbitrator, and they choose you for some reason. And some of the, these issues can take all kinds of, traditional theories come up in these smart contract, civil fraud, breach of contract torts, agency and partnership issues. For example, in some of the cases that have actually gotten into courts, they asked, are these tokens actually property? Are they security? Is it a commodity? There have been a lot of these initial coin offerings that the SEC has been investigating and determining whether they actually are securities. Should they have been listed or registered before they're actually offered? If you're involved, for example, in a divorce proceeding, how do you divide the currency, cryptocurrency, and if you sell it and you make profits, how are they taxable? If there's a pseudonymous owner, how do you identify them? And is that possible? And should that be possible given the how privileged anonymity is in this blockchain environment? Can creditors treat digital assets like cash? Some credit cards, in the beginning, if you bought cryptocurrency with a credit card, they would treat it as if it were just a purchase of property. Then suddenly they realized, oh, we can treat this as cash and charge a much higher interest rate on it. So some credit cards started treating it as a cash advance and charging higher rates. And at least one court has said, we see that as being a possibility, given that cryptocurrency has been treated as a different type of asset in different forum, but you have a type of contract with your credit card holders and you can't change it without advance notice. So at least in one case, they have told the cardholder, yes, you're right, you can't be charged a different interest rate without some notice. But it's possible that in the future, people may not want to use their credit cards to buy cryptocurrency. Does a blockchain operator have a duty of care to manage digital assets? And that has become a really serious issue. There have been many cases of these blockchain operators where fraud has become a real issue. There was a case in the Singapore International Commercial Court where it was actually a mistake, but Ethereum has suffered a number of fraudulent transactions and lost a lot of money for many of their owners, and is it their responsibility? Do they have a duty of care? And what is their responsibility? Can the membership in these blockchains, does it constitute membership for class action purposes if they want to sue the blockchain or operators? And there's an interesting case where a blockchain developer, one of its officers was consulting on a project with another operator developer on a similar project, and they sued trying to claim trade secret. And they said, well, no, this is not really a trade secret, but perhaps another court would hold differently. And then for those of you who don't know, Satoshi Nakamoto is the pseudonym for the person who basically developed the concept of Bitcoin. And many people have claimed after the fact to be Satoshi Nakamoto, but there's a case going on in Miami over the estate of one person who claimed to be Satoshi Nakamoto and the other person who is claiming over an enormous amount of money because of the Bitcoin phenomenon. And they're arguing about this right now. So if you were someone who wasn't familiar with the technology, how might you establish that given the technical elements of that claim? So from a technical standpoint, next slide, Angie, please. How do you understand the code when the technology, if it fails? And that's the issue. The oracle is something that in a smart contract, it actually pulls data from real world sources. What was the temperature on a certain day at a certain time that triggers whether a breach occurred or whether a term in the smart contract was satisfied? Did that fail? Did the parties agree that it worked correctly? How do you understand that code? And the zero state provenance problems. There have been many of these blockchains that have been touted to be the solution to provenance for all kinds of property. Marcia mentioned the diamond exchanges and the diamond tracing for the blood diamond issue, but they have, a lot of nation states have begun considering property registries. But you can have a blockchain that has perfectly recorded data, but if it's recorded improperly, and people challenge those records, you still have the zero state problem. It's recorded, and as Angie mentioned, it's forever recorded in that state. But people can still challenge the accuracy of the recorded data. And for developers of the code who are not lawyers, is it the unauthorized practice of law to develop a smart contract? And for lawyers who are advising those developers, are you aiding and assisting in the unauthorized practice of law? And for neutrals who are trying to resolve disputes, who's responsible for errors? If you have a party who is seeking your help to identify parties on the other side of a dispute, in a distributed ledger transaction, who is responsible? Who's the client for the other party on the other side? And then there's a lot of discussion about how this distributes power, but it also can actually cement an asymmetry of power by recording power structures as they are currently, instead of distributing them as people hype. So, if, for example, in property registrations, property is allocated in an asymmetrical way, that can just actually document a form of asymmetry of power. And that is something then forever recorded on a blockchain. And then, of course, blockchain can facilitate crime. That there have been a lot of cryptocurrency. It's been on the dark web. That's how a lot of crime has been committed, and it's very difficult to identify where those currencies are distributed. So has become an issue, although the FBI seems to be getting much better at identifying those folks. And then lost and stolen keys. Angie has talked about how there's a public key and then you have private keys, and those can be stolen. If people are careless with their keys, they can be stolen. And how do you verify that if you're the neutral and you're not? And there are two people who claim to be the owners of those keys. That's a problem that technology cannot solve, and it'd be very difficult for a neutral to solve. Next slide. So just some of the rules for lawyer neutrals who are dealing with smart contracts in the blockchain. One must always ask, we have the duty to be competent. If you're trying to resolve disputes in this area, are you competent? Do you feel competent? In some areas, if it's a contract dispute, sure, I'm competent. I think that depending upon the type of dispute it is, sure, I think many people are. But I think if it's an issue where two coders are disputing an interpretation of a piece of code, I don't think I'd feel competent to be able to be in the middle of that. The fee issue is there have been several states that have ruled on lawyers and lawyer neutrals, would I assume would be covered in this, accepting cryptocurrency and for their fees and the condition under which you can accept those. And most have said you have to, if you do accept the fees, which most states who have ruled on it have said you can, but you must convert it immediately so that you don't take advantage. You don't have it in an account where it accrues value or loses value. So you actually have to convert it right away. But I know that New York has ruled on it relatively recently, and I think maybe Wisconsin ruled on it. I will find it, but we will go on. Then safekeeping property, it's the same thing. If one of your clients asks you to hold cryptocurrency in trust, there are conditions under which you must do that. You can't commingle it with your own cryptocurrency. If you were to actually hold cryptocurrency in your practice for some reason, there are conditions under which you have to take care of that currency. And then again, the rules regarding your responsibility as a lawyer for assisting someone in the practice of law who's not a lawyer. So that would, again, if you're advising blockchain developers and they are creating smart contracts, what does your state have to say about the unauthorized practice of law? I think I'd take much care with that, because I think as you start seeing more cases arise from these smart contracts failing, that may become more of an issue and get more bar attention. And again, for mediators, I think quality of process and party competence, again, is going to be an issue. What can you assure a quality process? For example, if you have on one side of a mediation, a distributed ledger with unknown parties, and then competence. Do you feel competent that you will be able to understand the issues so that you can empower the parties in a way that allows them to resolve the dispute for themselves in a quality way? Okay, next. So Amy had talked about her research, and she identified the types of contracts or dispute resolution types that she had seen, and I've identified them too a little differently. I've seen the way that people have approached this as just taking advantage of existing contract law framework. They haven't tried anything really new. They just go straight to the courts or other existing ADR processes like mediation or arbitration. It's a smart contract, but when there's a dispute, they just take it to something already established. It's nothing new. Then there's this new Lex Cryptographia, which is blockchain-based distributed jurisdiction, because these blockchains go, as Marcia talked about, they're everywhere. And the developer may be in India, they may be in California in Silicon Valley, maybe Colin, and he may be working with a developer in China, and people all over the world mine the blockchain, and so it's everywhere. So there's no single jurisdiction potentially for any type of dispute. So they have an intramural dispute resolution that's coded within the blockchain, this if, then, and potentially oracles that will bring in data to help resolve the disputes. And then there are these new private decentralized dispute resolution mechanisms that Amy talked about and we'll talk a little more about in just a minute. And then there are hybrid approaches where they'll have a code in the blockchain itself that defaults to, it'll pause the contract, it'll terminate the contract, it will do something that then pushes people back out into the real world, into the traditional courts or other dispute resolution systems. So next slide. Colin, I think you have a lot of expertise in this one.
Sure. Well, I think Claros is very cool, so I'm happy to talk to it. It's funny. I think Amy called them doges, but I always call them dogies, but who knows? I don't know what the right pronunciation is. It's like GIF and GIF. We could debate that all day. But Claros is, I think, the most advanced. So they call themselves a decentralized court. When I talk about decentralized justice, a lot of that comes from Federico Ast and Claros, sort of thinking through what would the next justice system look like. They launched in 2019. They've done over 100 cases. And I think their aspiration is to be written into a lot of these smart contracts. So Claros would become essentially a crowdsourced dispute resolution process that could be coded directly into these platforms. So as Becky was mentioning, you could, just like we have arbitration clauses in paper-based contracts, we could also have theoretically ODR clauses in smart contracts, where if one or the other party flipped a switch, it would then go to a trusted intermediary process to resolve the case. So essentially what happens is Claros issued its own token, its own virtual currency called a Pinakion, and they have global jurors that sign up and they stake a certain amount of these tokens, and they are incentivized every time a case comes in and they're asked to weigh in on the case, you know, you want to be on the right side in terms of making the decision. And Claros has modeled all the incentives from a game theoretical perspective to ensure that all the jurors have an incentive to participate in good faith and provide good decisions. And the winning jurors take tokens from the losing jurors. So there was a simulation that Claros did, and this is what we were talking about in terms of doggies, where lots of people were incentivized to submit pictures. Doggies are a certain kind of Shiba Inu. It's a Japanese breed of dog. And people were incentivized to submit pictures of doggies. And actually, they had a huge incentive to submit a picture of a doggie that was actually not a doggie. And that they could get the jury to agree with them. And actually, the administration of that process, I think, reinforced Claros's scalability and its ability to render good decisions. There is an appeal process. Someone started submit pictures of leaders from the Medici era in Venice, which were also doggies, of course, and some of them got through. And the question was, okay, you said that we were supposed to submit pictures of doggies, and this is a doggie. This is the Doggie's Palace, and this is, you know, from 15 whatever. So there was a lot of debate about that, and there's a process through Claros where you can essentially appeal the decision of the jury, and you get larger and larger juries, but you have to stake, as the person who's sort of filing this case, you have to continue to pay more to get the additional layers of review because they bring in more and more jurors. But it's a very well-designed system. I think it's very well scaled out. The people that have put it together and the code behind it is pretty rock solid. And I think Amy shared a link. You know, you can go out and if you go to YouTube and type in Claros doggies, you know, you'll get to see all of the various pictures that were submitted. You know, I think that Claros is still looking for a real-world application that could test it in real cases where people have actual money. But I think right now it's the most sophisticated crowdsourced platform, and I think doing outreach to the cryptocurrency community, and they want to be sort of the #1 dispute resolution platform for that community. So they've integrated in with lots of different systems, and they speak the same language as that community. So I think it's very cool, and you know, it's worth going to check out their platform and learning more about how it operates. Amy, do you have anything you wanted to add on that?
No, that was great. I mean, I'm pretty impressed with how much they've really taken the time to research this. The Federico and others involved seem to really be, they are, in my view, at least it appears to me that they're really trying to do the best thing and trying to create something that could scale. So I give them credit for the hard work they put in.
Yeah, and I'll chime in for just a minute. They actually are doing cases. They're working on they're calling it air transport, but it's things like lost luggage. Mm-hmm. And what else? Car insurance, claims for car insurance, and freelancing. You know, my freelance software developer didn't do the job I performed, those kind of things. And, you know, they have said that they're building up to more complicated, but people have bought into this wholeheartedly for the smaller, like the more simple disputes, and it's very fast. I think that's why people have, you know, they've just gone 100% in, because these things they work really quickly, and you know, it's a fairly small amount of money. They don't, you know, it doesn't cost much to actually file, and very few people appeal. So I think it works really well. And I loved the doggie. I think maybe that whole experiment might have gotten them a very loyal following from the beginning.
And only because I can't help a chance to sort of pick on Colin a little bit, but it is Doge. I actually shared with you the YouTube pronunciation.
Is it really?
Yeah. But if it's Doge, is it also Doge in Renaissance Venice? I thought that was called the Doggies, but who knows?
Yeah, because I thought it was just when I talked to Federico once, I thought it was because he was mispronouncing doggy. You know,
Yeah.
I was I thought, you know, he's Argentinian. Okay.
Yeah,
So,
just go with it. Just go with it. Yeah.
was going with it. But
We
And I
should
wanna-
send a case about the pronunciation to Claros, and we'll let the jury vote on it.
I
I
like it.
love it. They would
One
go.
more.
I have a question about evidence that perhaps Colin or Amy, you might be able to explain to me. So it sounds like, you know, the Doge experiment was, you know, a fairly simple contained piece of evidence. Like you look at the picture, yes, no, 0, 1. But in some of the actual contracts disputes that they're starting to solve, and maybe Becky, you can weigh in on this as well, what does the presentation of evidence look like?
I haven't seen any of the evidence. You actually have to be a jury, one of the jurors, to get access to the evidence. But I mean, I think you can present anything you want.
Yeah, I sat down in a coffee shop in Montreal with one of the guys from Claros and watched exactly, it was a trial having to do with cryptocurrencies and whether or not they should be listed on a particular exchange as being valid or not valid. So it was a trial basically on whether this cryptocurrency was valid or not valid and should be included on this exchange. And it was really impressive because it looked to me at least that the way they presented the evidence was almost as though you present evidence in any sort of online arbitration. And there were briefs and there was the evidence and they uploaded it, each side did. And it was really quite well, the procedure seemed to be secure. They were using various encrypting the evidence submissions. And so to me, it was pretty impressive. It looked to me like it was very much being controlled in a legitimate manner.
I have another question actually, and I'm looking at this, and I watched some stuff on Claros before. I'm just wondering how much they plan to scale or how complex they expect the cases to be, because I'm not sure that some businesses want paid jurors who may or may not have any expertise, who are really, and I do look at this as a kind of a gamification process, to be deciding this. So is Claros saying that there's a box we're going to stay in and we're not expecting to play in certain other lanes, or is Claros thinking the sky's the limit?
Yeah, I talked with Federico about this. We co-presented at a conference in the UK a couple months ago. And as we were talking about different application areas, you know, we built something at eBay called the Community Court. And it was a similar kind of crowdsourced approach. And actually, Taobao, which is one of the marketplaces run by Alibaba in China, they're resolving millions and millions of these e-commerce cases using similar crowdsourced techniques. I think Erin's point is well taken too. I think a lot of these are systems design questions. And one of the things I said to Federico is, you know, just random people that buy Panakian tokens, why do they necessarily have the expertise to decide an insurance case? You know, you might want to say, we're going to build a specialized panel of people that actually have expertise, that have some credibility and knowledge. I think Erin's point about the submission of evidence is also an interesting one as well. You may design one system, which is high volume, low value cases. It's fine. You don't need expert people to come in and evaluate. You know, maybe all of the information that the jurors use to decide the case is sort of automatically collected and provided. But then you may build other flows with their higher dollar value cases. You may have specialist juries where all the people on it have to meet a certain eligibility criteria that has expertise. Maybe it's a documents only arbitration, or maybe there's even an opportunity to call witnesses or submit other pieces of evidence. So I think, again, it gets back to what Amy's saying about fitting the form to the fuss. I think as they start to tackle other case volumes, they're going to have to figure out who are the panelists, how much evidence, how much procedural overhead do you want to put. If it's a $100 dispute, you know, you don't want it to go on for weeks and weeks. But, you know, if it's a $100,000 insurance case, well, then maybe you do want to submit some photos and some bills and some evidence, you know, that would be relevant to the case, and have people evaluating that have expertise in the industry, so that you know you have a more trustworthy outcome. But I think that the core fusion here, the innovation here, is the idea of kind of crowdsourced justice, you know, this sort of e-democracy combined with justice. If you have a really large panel, you know, you could have hundreds or thousands of people weighing in on a decision, and that improves the unimpeachability and the perceived fairness of that decision, because it's not like all those people could be compromised. So, you know, there's a lot, I think, of systems design challenges that they still need to surmount. But I think the core architecture is trustworthy, and the people who have looked at it, like Amy and me and others, you know, it's impressive. They've done a lot of work to try and get it right.
And remember that a lot of these, all of these are new. So I think they're testing, they're still in the modest test phase, and they're still trying to determine what they're doing. I mean, they know the code and they know the structure, but they're still exploring their jurisdiction, so to speak. You know, what exactly will their cases be? You know, what will it work best with? So on that note, let's move to the next one because it's very similar. So this, they claim to be the first of these types of court, but it's very, very similar to the way that Claros is designed. The disputants post a bond and they provide evidence. Jurors are selected. Again, they have you to become a juror, you have to have a stake. And they review the evidence. They rule, again, the way they think that the plurality of jurors will rule. If you rule in the minority, you lose your stakes. All the stakes are locked. And in all of these, nobody knows how anybody's voting. It's all, you know, you keep the votes locked until everything's revealed. So the alleged, you know, the theory is that there's no way that you can subvert the vote. Now, that's the theory, and hopefully Amy and Colin can talk a little bit about that, the 51% issue, which is a lot of the criticisms of these types of jury, you know, the kind of gamification of these, but they have defended that these systems actually work. The majority jurors here are rewarded with the dispute fees and the tokens that the minority jurors lose. In this, it's interesting though, anybody can pay the fee to appeal, not just the parties. You know, if you don't like it, if you're the minority juror and you lost your tokens, you can appeal if you're willing to post a bond. And you can have multiple appeals in each time. And there's actually a formula, a mathematical formula based upon the amount the amount of the case and other data factors that increases the number of jurors in each appeal until, if it goes on, every juror that they have listed potentially could become involved in the case. So that's how that one works. And they went live in February of 2020. You can see they already have 276 jurors in their pool, and I forget what it's an A&G is their stake, their tokens, and it's not a small amount of money to buy one of these. So, you know, to have 276, they actually have some buy-in. There's a fairly prominent investor invested in them a significant amount of money. So they have some stake behind them to succeed. Do you guys?
I'll just say I'm an Aragon juror, and you know, it wasn't that much money, but you know, you had to stake something, and again, theoretically, you get it back. You know, but you do need to put some money in, you know, in terms of converting to their currency. I will say Federico made a good point when we were at this conference in Leicester about these crowdsourced juries. You know, one of the things that he said, he put up a slide and said, you know, what U.S. state is close to Africa? And, you know, everybody kind of looked around in the audience and most people said Florida. And he said, yeah, if you ask the majority of American citizens what state is closest to Africa, they say Florida. But the answer is actually Maine. Now, so the problem is with a crowdsourced jury, if you want to keep your money, you know, and you know that you're right and that everybody else is wrong, you actually don't have an incentive to say the right answer. You're trying to guess what everybody else is going to guess. And that may mean, I think, you know, people are not that smart. They're going to make the wrong decision. So I'm going to make the wrong decision too, because I want to make my money. So I think, you know, you were talking before about sort of the gameability, these mechanisms, you know, the wisdom of the crowds only goes so far. Mm-hmm. And, you know, if you've got smart people, well, then you probably have a greater chance that the wisdom of that crowd would be good. But if you just got a random selection of people out there, there's no guarantee that necessarily. So just like we talk about how in machine learning and AI, you may see bias introduced by bad decisions in the past will lead to bad decisions in the future. I think you have some of the same risk with these other issues. And Aragon, it was interesting. I was part of a case that got put to Aragon. It was an actual case around the cryptocurrency purchase, and the Aragon court rendered a decision. And it was fascinating to read the messages from the participants in the case who were like, what is the Aragon court? I mean, it had no awareness that this decision had zero trust and zero credibility with the people who received it. So that's going to be an issue for these as well, as awareness spins out. It's not just about having a procedurally just system. You have to have awareness and trust and understanding of how the mechanism works, so that when a decision is rendered, it actually has credibility, so that people don't say, is this just made up by a bunch of, I don't know who it is. I have no visibility into the process. All I know is I got an outcome, and maybe I disagree with that outcome, and why would it have legitimacy for me? So I think all those questions we need to address.
I read an interesting article by one of the developers of the Aragon court who said that in the end, he thought it would take a court to legitimize these systems. That he said exactly what you just said, Colin, that, there would have to be buy-in by the parties, but ultimately, if a party didn't like what happened, the legitimacy would mean nothing. It would have to be a real world court that would provide the legitimacy for these, and he thought that eventually that would happen because the parties had agreed to the process, and then a court would say, well, that's just too bad that you didn't like the result. He thought that that at some point there would be, I see your note, Angie, there. But he thought that at some point it would get to the courts, and that would provide potentially or it might be legislated. But he didn't think that they would develop the legitimacy on their own. But I thought that was an interesting kind of observation on a developer of these systems on his own. But I thought it was probably realistic.
Well, and I would say that really jives with my eBay experience. We did 60 million disputes per year, and we had our own terms and conditions. We built our own resolution process, but it was not a pre-dispute binding arbitration process. Anyone could appeal those outcomes in a court, but 99.999% of the time, nobody ever did, because we're talking about a $75 or $100 dispute. And the cases that did eventually make it to a court with a plaintiff, a complainant who's just really aggrieved, so they were willing to pursue it, even though it made no financial sense for them to do so. Eventually it would get to a judge, and the judge would say, I don't know anything more than eBay. I'm just going to go with whatever eBay decided. So it did essentially communicate credibility to our process, and then the parties stopped appealing. They would say, okay, this is the definitive process. The other thing was, it was fair. It was administered by eBay, the marketplace coordinator. So I think that is actually right. The courts are going to have to weigh in and say, look, we don't want these cases anyway, so this process is fine, and we're going to stand behind it. And if somebody does appeal it up to us, we're probably going to go with what the court said, and then people will just learn, okay, this is the last level of redress for these kinds of cases.
Well, and as they get more publicity and more people are aware of them, like the eBay process, then there will be more acceptance of the results, probably. Angie, you want to move? We'll go much more quickly.
Yeah, so I know that we're getting close to the end on time. As our audience surrogate, I do want to make sure that we allow some time for questions. Marcia, did you have one before we move forward?
Yeah, so I have a question as if I were an actual arbitrator watching this, knowing it's online dispute resolution and not necessarily alternative dispute resolution, but it still begs the question, when you guys are contract professors, I teach contract drafting, and we spend a lot of time talking about the ADR provisions and the fact that many businesses would never want a jury, much less a jury of people who pay tokens and do the whole theory of, well, most people are going to say Florida, but it's really Maine, so I'm going for Florida so I can win. So I guess the question is for those audience members who may not be enmeshed and may be like me saying, why would anybody want this? Number one, Colin, what is the incentive to be a juror? And number two, what is the incentive for larger claims to use this process versus just having some code that says this is going to a more traditional ADR, ODR process, a trained arbitrator who understands the rules, the competence, all of those kinds of things?
Sure. Well, I think these are great questions. I will say in the eBay context, when we went out and we started signing up jurors, I thought, well, we're going to need to provide incentives for people to do this. Like, why would they just do this out of the goodness of their heart? So we actually got a slush fund of $5,000 to give out gift cards to people who were willing to decide these cases. I never paid $1 out of that fund. I was overwhelmed with people that wanted to be jurors. And, you know, we used to joke, there's so many bored grandmas in the United States that want to be Judge Judy, you know, and they're making their money on eBay, you know, like that's where they make their money. So they see this as community service. They also see there's a lot of bad actors out there and they love feeling like they can give back. Now, we started a community court at PayPal as well. Now, eBay is more of a community. I mean, there's a connection there. We're all part of the eBay community. At PayPal, it's more like MasterCard or Visa, you know, it's just a payment mechanism. So I said, who wants to be a juror for the PayPal community court? Crickets. No, you know, there was nobody because it didn't have that same kind of community orientation. And if you did get a jury of fellow PayPal users to decide your case, be like, I have nothing in common. I mean, you know, like, it's not like you see someone at the grocery store and they pay with Visa and you go, oh, hey, I'm a Visa customer too, you know, twinsies. No, there's no affiliative connection there through payment mechanisms where, you know, I used to wear my eBay shirt in the airport and grandmas would come up to me and say, I love eBay. I buy my Hummel figurines on eBay. Then I'd wear my PayPal shirt. No one would ever say anything to me. Sometimes they would glare at me from across the terminal because we took their money, you know, for various and sundry fees. So I think that it's a question of systems design fitting the forum to the fuss. If I was a business person and I saw Claros and there was a bunch of random cryptocurrency nerds who were staked and they were ready to handle my case, I'd be like, I'm not going to use that. But hey, if they get a panel of 100 people that are all in my industry and they have expertise, and I can go use that process for a fraction of the price for filing a case with JAMS or AAA, sure, I'd think about it. I mean, again, somebody would need to set that up and market it, and I need to understand the process so that I would elect to use it. But I think it gets to this point too. It's going to volume over time will build along with credibility, just as you start to put some cases into it. And I think that this, you know, as we said in China, this Taobao jury has enormous credibility. And yes, there is the potential for gaming, and you do have to monitor the performance of the jurors. But once the system is set up and you see you get good outcomes and it's faster and it's fairer and it's more transparent, you know, I could see why people would make the selection to use that mechanism, but it's going to take time for it to build credibility.
Thank you.
So I'll just run through, here's another case study is Jury Online. They are actually specialized in dispute resolution for initial coin offerings, and they have milestones throughout the offering process, and for a set period of time after the milestone, you can file some type of objection, and they have panels of experts who either are randomly selected or an arbitrator who is agreed by the parties. And so that's a little bit different. It's not as, you know, it's not kind of this juror, this crowdsourced juror, and it's for a specific type of dispute. Angie, next. And then the Blockchain Arbitration Forum. This is a kind of a hybrid system. It's an interesting system. It's smart contract based, and they offer arbitration, and they say other dispute resolution systems, they have a database of neutrals with legal and technical background. So this gets to they have expertise. And their rules, they have code, and they're based upon the UNCTRA arbitration rules, and they basically will pause, resume, modify, or terminate smart contracts. And they offer conventional contract language to corporations or entities that will then trigger contract language in the smart contract that will either pause, send to arbitrator, terminate, modify, whatever the code language that corresponds to whatever is in the real world contract. And it will notify whoever the appointing authority is as defined in the Blockchain Arbitration Forum's rule. So this is an example of one of the hybrid systems where there's both a contract in a traditional contract sense and then the smart contract, and they work together to provide the dispute resolution. Okay, next. And then there are all these other ones. And they have different functions. I think ECAF is no longer extant. It was an arbitration system, and it has gone the way of the dinosaurs. And Colin, what happened with SageWise? I thought it was it was another hybrid system. It seemed great, but I haven't found anything on it recently.
Yeah, they had to pivot. I mean, again, super smart. Amy Wan, their CEO, was really committed and, was just really leading the market. But I'm an advisor to SageWise, and there's not enough smart contracts. I mean, there's not enough disputes for them to make a business out of that. So they had to find other, so they've actually pivoted to making online mobile games where you get paid in cryptocurrency as you play. So, which turns out to be a very lucrative niche.
Yeah, when you put in their
wins money,
it takes you to that link.
Yeah, takes you to that link.
And I thought, wow, what happened?
So, I mean, SageWise was amazing. I think the challenge, again, this looks a lot like ODR looked, I would say, in 2000, 2001. Tons of small companies innovating, throwing spaghetti against the wall. They've got to, find a market where they can make enough money to survive. Or just continue to raise money. So this is what innovation looks like. What they call creative destruction. Lots and lots of companies coming in, and lots of them failing, but some of them getting stronger, and maybe all of them will die. But then growing out of the bones, you see green shoots. So this is what it's going to look like as you try out lots of models to see which ones win.
Anybody else want to say anything about any of these? I just wanted to go back to the ethical issue, the currency, on the rules on, there's a Nebraska ethics opinion that advises lawyers who accept digital currency as fees for any service to convert it into US dollars immediately on receipt at objective market rates through the use of a payment processor, and to credit the client's account at the time of payment. So that's Nebraska. The New York City Bar Association went further, and they said that if you accept cryptocurrency, you have to comply with ABA Model Rule 1.8a. North Carolina has opined similarly. So several rulings on that. The ABA has kind of reposted these, but I don't think it's done anything independently yet on the issue. But cryptocurrency is creeping into even legal payments. So it's something that we need to know more about as lawyers. And ethically, I think we can't pretend we don't know about it and actually work with it. So, Erin, did you have questions that you wanted, that anybody had wanted to ask, or?
I don't have any more questions right now, but do any of the other panelists have any? Okay, seeing none, I think I'll say next slide, which is our thank you slide. I know that this is a challenging time for many of us. I know that probably everybody who's watching this wishes that they were at the ABA Dispute Resolution Conference in spring in New Orleans. But we're very excited to be able to offer this as an online experience. And I've heard from a lot of people in my field, both practitioners and academics and people who are building out commercial platforms or service providers, that they are going to be participating in the virtual conference. So this is a plug for other bits of the conference. Please do check it out, because it will be fun. And I would just want to say thank you to all the panelists. I learned a ton in this hour and 20 odd minutes, and I would encourage anybody who's watching this that if you want to learn more, we do have Amy and Colin's article as part of the conference materials, but just Google Angie, Marcia, Becky, Colin, Amy, just Google their names and you will find links to their writings, to videos that they've done. So you'll find a lot of information just from the people that are here on this panel, as we've learned, or at least as I have learned, there is a lot to know. There's a lot of platforms out there. There's just a lot about the technology and how distributed ledgers work. And I'm still sort of wrapping my mind around the hashes and the oracles and how those bits of code work and impact things that are the real world. I mean, we think this is digital, but I think now more than ever, we're realizing that this digital world is also the real world and is increasingly our world. And I think that, beyond the sort of ethical questions of competence and the lawyer professional responsibility rules, I think at this point, I really hope that everybody who's listening to this is also just sort of thinking critically, as Amy framed it, about these dispute systems design questions. And really the themes that I was hearing come out most salient to me are these notions of, is this a community-based form of conflict resolution, or is this something that's going to become increasingly privatized as a form of dispute resolution? And how is that going to impact the field going forward? That was a theme that really resonated with me. But thank you just to all of you for making this happen. It's been very enlightening and I had a ton of fun. So thank you very much.
Thank you.
Guys,
Thank you.
it was really
Thank you.
fun.
Thanks, everybody.
Thanks.